So far, I've kept my mouth shut, partly out of respect for my colleagues' superior wisdom and experience, and partly because my ideas are so different, even from other delegates from my home state. But this is serious. So to heck with political correctness. I don't like the Virginia plan, and I like the New Jersey plan even less. I agree with Mr. Randolph regarding our authority and responsibilities. We were sent here to provide for a system of government that works. This is an emergency, and the people expect us to provide the best solution possible, and I don't think they're too concerned right now with technicalities. A solid system of government has the support of the people, the power to govern effectively, a means of enforcing the laws, and participation by the governed. There are many reasons why neither plan proposed so far fulfills the necessary requirements. My plan does. Here it is. The national legislature consists of two bodies, the Assembly and the Senate, which together have the authority to pass any law, subject to the following. Members of the Assembly are elected by the people and serve 3-year terms. The states will be divided into voting districts, and the people in each district will choose an elector, and the electors will elect senators, who will serve life terms. Any vacancy will be filled by someone from that senator's home district. Those same electors will also choose the executive, called the governor, who will also serve a life term, and who will have the authority to execute laws, veto any law passed by the legislature before it goes into effect, direct war when authorized by the legislature or when attacked, make treaties with the advice and consent of the Senate, appoint department heads and officers of the Departments of Finance, War, and Foreign Affairs, nominate other officers, including foreign ambassadors, subject to approval by the Senate, pardon any crime except treason, which would require Senate approval. If the governor dies, resigns, or is otherwise removed from office, the vacancy will be filled temporarily by the President of the Senate until a permanent replacement is appointed. The Senate has the sole authority to declare war, advise and approve all treaties, approve or reject all appointments of officers, except heads or chiefs of the Departments of Finance, War, and Foreign Affairs. Judicial authority is vested in a Supreme Court with a specified number of judges who will serve life terms and receive adequate, permanent salaries. The court will have jurisdiction. The legislature will also establish courts in each state to determine all matters of general concern. The governors, senators, and all officers of the United States are subject to impeachment, and upon conviction will be removed from office, and they will be disqualified for any position of trust or profit. Impeachments will be tried by a court, consisting of the Chief Justice or judge of each state's superior court. Any state law in conflict with national law or the U.S. Constitution is null and void. In order to help prevent such a law from being passed in the first place, each state governor will be appointed by the national government, and that governor will have veto power over any state law. No state will be allowed to maintain its own land or naval forces. Each state's militia will be under the exclusive control of the federal government, who will also appoint and commission their officers.
The delegates listened politely to Mr. Hamilton's plan, then ignored it.
We, some of us at least, have been making such a big deal about a federal form of government and how this convention isn't authorized to consider any other form. A lot has already been said on the subject, but I'd just like to add a few observations of my own. Exactly what is a federal plan of government, anyway? For one thing, its power and authority are exercised over not the people individually and directly, but on the people collectively on the states. But in some cases, under the current Confederacy, and to some extent under the New Jersey plan, the law applies directly to individuals. Piracy, for example. Similarly, members of a federal government aren't elected directly by the people, but are chosen one way or another by their state government. But in Connecticut and Rhode Island, delegates to Congress were chosen by the people at large, not by their state legislatures. And nothing in the New Jersey plan proposes any change in that regard. So, let's not pretend everything is all that cut and dried. And here's another thing for you to chew on. The states have violated the terms of the Confederacy many times. We're all familiar with the stories. My favorite is the one where New Jersey herself expressly refused to comply with Congress. So, when the delegates from that state suddenly develop such a strong devotion to the principles of federal government, it strikes me as a bit hypocritical. And from a legal perspective, since the sacred Treaty of the Confederacy has already been violated time after time, that renders the entire treaty null and void. So, let's stop wasting time getting all worked up over the unanimous consent thing. We have more important things to worry about. Now, let's take a look at the New Jersey Plan's objectives: preserve the Union and correct our current problems with the states, both individually and as part of the national government. Does it get these jobs done? I see no evidence that it will do anything at all to help preserve the Union, and I can think of at least 8 good reasons for doubting that it will solve any problems with the states.
Immediately after Mr. Madison finished speaking, the convention voted to set aside the New Jersey Plan and resume its consideration of the Virginia Plan.
It's important to find the right balance of power between the national and state governments. I'm afraid we might be tending to give too much power to the federal government at the expense of the states. Good grief, Mr. Hamilton's plan essentially does away with states completely.
True, we need to find the right balance, but the evidence shows that the greater danger is from the states at the expense of the federal government.
If we take a look at other confederacies throughout the world and in history, we find that they tend to end in anarchy rather than tyranny. It's the same with us. The danger is from encroachment by the states, not the national government. Look at Connecticut, for example, where they have incorporated townships and each one has a certain limited jurisdiction. Has the state government encroached on their authority? I don't think so. And even if there were to be some encroachment by the national government, it would cause less harm than encroachment by the states. In order to answer the question of whether long or short terms would be better for senators, we first have to ask what we expect of them while serving in the Senate. For one thing, they should help protect us from our government, even though they are a fundamental part of it. That means, among other things, that they are to avoid corruption. If they serve for too long, there is greater risk of betraying the people's trust and of becoming part of the problems, rather than offering solutions. On the other hand, they need to serve long enough to fully understand the complexities involved in our national government. They need to have time to learn, and once they have learned, we don't want to waste that knowledge by turning them out too quickly. I think 9 years would be about right.
I'd say 4 or 6 years would strike the right balance.
I don't want to offer a specific number, but I'd just like to say that Mr. Madison was right when he commented on the importance of getting it right. If we blow it, the Republican form of government will be disgraced in the eyes of the world, and it may be lost forever.
Madison, Wilson, King, Morris, and others opposed giving each state an equal vote in the Senate, because the states varied widely in size, thus violating the principle of equal representation. Johnson, Ellsworth, Bedford, and other delegates from small states supported it. Over this 5-day period, the discussions were heated and intense. This is just a small sample of the debate.
We'll never be able to reach a decision if we can't even agree on what we disagree about. Some say a state is a single political society, others say a state has many political societies within it. Both are correct. A national government needs to be able to accommodate both the state as a single political unit and the individuals within it. How it does that depends on the situation.
But the people as individuals are more important because states are simply artificial political entities made up of some of those individuals. It would be absurd to emphasize states so much that we lose sight of the individuals of which states are made. The smaller states claim that if they give up an equal vote in the Senate, they are in effect losing their liberty. But the truth is that it's not about liberty, it's about power.
Are we forming a government for men or for some imaginary entity called a state?
Some of you would like us to believe that we have nothing to fear from larger states, because, instead of teaming up against the smaller states, they will develop natural rivalries between them, and thus prevent each other from getting too powerful. Yeah, right. The large states will be rivals, all right, but not against each other. They'll be rivals of the smaller states.
Okay, so whenever it is more appropriate for the national government to recognize states as a collection of individuals, as in the House, We have votes based on proportional representation. And whenever it is more appropriate for the national government to recognize states as single political entities, as in the Senate, each state has an equal vote. I get that. What a wonderful compromise. Just one little problem. There is never a legitimate situation in which it is appropriate for the federal government to treat people as anything other than individuals. Anything to the contrary has been thoroughly debunked.
If the executive is chosen by popular election, the people will decide wisely. On the other hand, if left to Congress, their decision will be the result of political dirty tricks.
The people aren't well enough informed to make wise decisions in matters like this. They will tend to vote for the candidate from their own state, so the largest state will usually prevail. We should let Congress choose the executive.
Do we really have to discuss this again? The biggest states will get together and support a candidate, so no others will even have a chance. Since Congress makes laws, and the president executes them, there will naturally be a cooperative relationship between them. It will be in Congress' best interest to make good choices, so we should give them the job.
It's ridiculous to say that the people of the larger states will get together and force their will on the rest of the country. How in the world would so many people get together for anything? If anyone will get together, it's the members of Congress. It's also not true that the people would be easily manipulated by a few unscrupulous, ambitious men. Maybe in a small district somewhere, but not all over the country.
The people are no more competent to judge candidates than a blind man is to judge colors.
One of the primary functions of the executive is to control the legislature. If he is chosen by that legislature, that will compromise his independence and his resolve to restrain their natural inclinations toward encroachment and corruption. The executive is the guardian of the people, and should, therefore, be chosen by them.
It is a fundamental principle of free government that the executive, legislative, and judicial branches must act both separately and independently. Executive election by the legislature violates that principle.
I don't much care for either option, especially popular elections, because the people are uninformed and easily misled. I have a better idea. The people in each state will elect representatives. Each state legislature will choose senators. The state governors will appoint electors who will choose the president. This would promote a close working relationship between the national and state governments.
Every time I suggest this, it gets shot down. But I'm not giving up. The judiciary can declare a law unconstitutional, and that's fine as far as it goes. But a law can stink on ice and still not violate the Constitution. So, we need to give the court more discretion in weeding out bad laws.
I second the motion.
A justice is not supposed to get involved in policy, but I don't see any reason why a justice couldn't express an opinion if the president asks for it.
I think it's a swell idea. The president can't be expected to be a legal expert or constitutional scholar, so why should he not take advantage of the court's expertise, especially in the area of international law?
This is a win-win proposition. It would help the court by guarding against congressional encroachment. It would help the president because he would have more confidence in his legal conclusions. It would help Congress make better laws. And it would help the people in general because it would help prevent unwise and unjust laws. I've always supported this idea. Without it, the president's revisionary powers are meaningless.
I had hoped we wouldn't need to have this discussion again. It violates the principle of separation of powers. Judges are supposed to be guardians of the rights of the people, not statesmen. If we're worried about Congress passing bad laws, why don't we do what Pennsylvania did? Hire a legal expert to help them.
I agree with Mr. Jerry. Making laws and judging their constitutionality are two different things. Everybody knows that.
We do need some sort of checks and balances scheme for keeping Congress under control. But I don't think either the president or the court is in a very good position to do the job. Probably the best we can hope for is that the press will help by exposing potentially bad laws to the public.
This is a bad idea. There's no reason to assume that judges have any more wisdom or legal expertise than anyone else, except in the narrow area of whether or not a particular law complies with the Constitution. If, in addition to that power, we give them revisionary rights, they will have a double negative. We expect people to have confidence in the justices, but that will be lost if they advise against popular laws.
It's not good enough to just talk about separation of powers. We have to find ways of making sure things actually work that way in practice. This provision is one of those ways.
The primary reason for giving the president revisionary powers is to prevent encroachment by Congress. But another benefit is that it will discourage demagogues from trying to pass bad laws. And I don't have a problem with justices getting involved in the process because instead of just declaring laws unconstitutional, they can help make sure such laws don't get passed in the first place.
I propose that judges be appointed by the president, subject to approval by 2/3 of the Senate. The executive is in a much better position to make good choices in this case than Congress, and unless the president's choice is extremely bad, the Senate will go along with it most of the time.
Judges should be appointed by Congress. The people won't have confidence in the president's ability to make good decisions in this area.
If left to Congress, they will select their friends or political allies, not the best qualified people.
No, it's the president who will be tempted to base his decisions on personal or political considerations, and the people know that. Besides, he'll be stuck in Washington, so he won't have any idea who the best people are for the job. Furthermore, Congress will never reject the president's choice, so their right to do so means nothing.
For one thing, having the Senate appoint judges would present a potential conflict of interest, because a judge may very well end up presiding over a case in which a state is a party or has a vital interest. It would be almost like having a person act as his own judge. Another thing is that the president would not be any more inclined to appoint people based on personal or political reasons than members of Congress would. And he will not be stuck in Washington, because his job will take him to all areas of the country, so he will know people, and he will be in a good position to find and appoint well-qualified people. It's ridiculous to trust the president to be commander-in-chief of the military, but not trust him to appoint judges. And one more thing, there is no reason to assume Congress will not use its rejection authority when appropriate.
One of the goals of the Constitution is to balance the legitimate interests of both the people and the states. That's why the Senate, not the president, should appoint judges.
Some of you don't like the 2/3 requirement for Senate rejection. I'm open to changing that to a simple majority.
That doesn't make much difference, because the Senate is not likely to deny the president his choice of judges. And that gives the executive too much influence over the judicial branch. Some have expressed concern over the issue of the different interests of northern and southern states, but I don't think we have to worry about that in the judiciary. That could be a problem when dealing with taxes, commerce, and navigation, but not so much regarding judicial appointments.